All right, so I'm here again with Damien Grant, and we're here to talk about shareholder appointed liquidators. So,
What would you like to know?
so Damien, there is this perception out there, and I may also be a holder of this perception that a shareholder appointed liquidator is going to be friendly to the directors. Is this true, or what's your perception as a liquidator?
It's not universally true, um, but it is certainly a feature of insolvency. So, and I'll just talk through how the incentive structure works. So, if you're a liquidator, you will have a referral network of maybe 30, 40, 50 people, primarily accountants and lawyers. So if you get a call from one of the people who refers you to appointments and they say, oh, listen, I've got Nigel, he's a really good guy, he needs to put his company into liquidation. Once you're appointed, if you find that Nigel has a grossly overdrawn current account, has traded recklessly, if you then proceed to pursue Nigel and bankrupt him and take his house, then that lawyer or accountant, next time they have somebody in that situation, in good conscience and quite ethically, thinking in the interest of their client, is not going to refer that particular that particular client to you. And so that places a real moral hazard on liquidators, because we know that if we take an aggressive approach, we may potentially burn that source of work going forward. That's one of the things that regulation is attempting to address. So if you are a liquidator in that position and you decide not to pursue a current account or a breach of duties claims, then the auditor from the regulatory authority is going to ask you, okay, why did you not do that? What was your reasoning and thinking behind it? But nonetheless, even notwithstanding that, liquidators have a fairly wide degree of discretion in the decisions that they take. Now, contrast that with a court-appointed liquidator. A court-appointed liquidator, you've been appointed by the creditors, or at least one creditor, and the creditor is going to want you to take a really aggressive approach.
Yeah.
And so again, your incentive structure is different. Now, and certainly firsthand, I've seen examples where people's behaviour, look, and you can never know. We don't have a window into people's souls. But I think if you work on the assumption that liquidators are people too, and I realise that's a difficult assumption for some people, liquidators have an incentive to act in a certain way, and it's going to be very difficult, even with regulation, to really stamp that out. So that's in a nutshell why, and creditors can be very suspicious of a liquidator who's been appointed by a director for exactly that reason, for the shareholders. So my advice in that situation is always call a creditors meeting, because if you are not certain, and remember, one creditor on their own can call a creditors meeting and get the liquidator, and the liquidator often may well respond to an engaged pool of creditors.
Well, see, because I'm in this interesting space where I can wear two hats. So sometimes I act for the shareholders, and where I'm acting for a shareholder, my advice before we liquidate is typically, look, there are things that a liquidator can do, and then there are things that a liquidator must do. So my role is often to structure the company liquidation in a way that triggers as little as possible of the musts, and then you just kind of cross your fingers on the cans, and where I'm acting for creditors, my advice often is, let's call a creditors meeting and roll this liquidator. And if you take a very robust approach at a creditors meeting, it is possible to gain votes. Actually, I should probably take a step back. I mean, the creditors meeting itself is the only real practical opportunity to replace the liquidator. And so if you get the majority in number and value of creditors voting to replace the liquidator, he's gone. And so, beforehand, we work pretty hard to get creditors on side and get them voting our way. And even at the meeting, we're working hard to persuade those in the room. And I've been at creditors meetings where, it's been we've been unsure of whether or not we're going to get the liquidator out. And we had people putting their hand up. We had a guy put his hand up and said, "Hey, can I change my vote?" And before the liquidator could answer, I was, "Yes, absolutely, you can." And then another person said, "Yeah, I want to change my vote also." And I suppose if all the information they've had has been from the liquidator, and then they see this process unfold, it's possible to change people's minds. It's pretty hard if they've done a postal vote, but yeah, I mean, my perception often is a shareholder appointed liquidator is going to be more friendly to the interests of shareholders, and particularly if it's not a reputable liquidator who doesn't take their obligations to creditors seriously.
And my other advice in that situation is, if you're going to do that, you should always opt to get a creditors committee, because although a creditors committee doesn't necessarily have any significant legal power, it's got some, but it's of no real value. What a creditor committee does, it is a means by which you can continue to engage with the liquidator. And most insolvency practitioners, I've probably got about 400 files on my books. There's probably about 20 or 30 that I'm actively dealing with at any one point in time. And I need to make a decision about where I allocate my resources, because most of these files have nothing in them. If I have a creditors committee who is engaged and who wants me to do something, and I know that I'm going to have to report to them, once every 6 months when we meet, it's just a squeaky wheel syndrome. And so if I'm allocating my time, particularly because of most of these files I know I'm not going to get a recovery, it's only human to say, right, I've got these files and the creditors seem disengaged. I've got these other files where the creditors are absolutely engaged. And I've got the opportunity to, earn some positive praise or avoid a rebuke. Then a liquidator is just going to respond to that, because liquidators, we obviously operate in the commercial environment where people too. So a liquidation committee does give creditors the opportunity to not just hold the liquidator's feet to the fire. I think that's unfair, but just engage positively with a liquidator, particularly if the creditors have been successful in changing the liquidator.
Yep, absolutely agree. And that's been my experience also. Squeaky wheel gets the oil, and if you're silent, often the liquidator will be silent also. All right. Well, thank you for your time. I think that's a wrap.
It was a pleasure, Mr. Norling.
Likewise. Bye.
We'll talk soon.